Welcome back to our video interview series. I'm Jesse Bauer with Sarasota Gulf Coast Homes.
I'm Stephanie Hoyer.
And I'm Ryan Rupp.
And this week we'd like to introduce Mallory Bauer of Berlin Patent Ebling. Mallory's, we've been holding off on this one for a long time, and I'm very excited about this one. So Mallory, why don't you tell us a little bit about yourself?
Hi everyone, my name is Mallory Bauer. I'm an attorney with Berlin Patent Ebling. We are a full-service real estate law firm. We started in Sarasota, and we've grown to about 6 offices now. We go to St. Pete, Tampa, Lakewood Ranch, Venice, and most recently Bonita Springs. I always like to say that we touch every part of the legal aspect that involves real estate. So we have a litigation team, we have a trust and estates team, a business entities team. So anything that is involved with real estate, we can handle and be the one-stop shop. So thanks for having me today, guys.
Of course, yeah. Thank you for coming on. And in case anyone was wondering, yes, this is my wife, Mallory Bauer, and Jesse Bauer. Stephanie, did you have a question to start us off?
Yes. So let's start really basic. We wanted to know for our public, for everybody to know, buyers, sellers, what is the difference between a title company and an attorney?
Yeah, great question. So I know a lot of states in the United States have attorney-driven states or they have title-driven states. So I know you're always working with out-of-state buyers. They might ask, who do I work with, an attorney or a title company? So Florida does not have a hat that they wear. They're not an attorney state or they're not a title company state. However, we pride everybody to use attorneys in the state of Florida. The biggest difference is that a title company doesn't have an attorney that represents that party, whether it's the buyer or the seller. A law firm has that. So depending on who's picking and paying in the contract, that party, either the buyer or the seller, is actually represented by an attorney. It's usually no difference in money. Title company and law firm have pretty similar fees. So you're basically getting free attorney representation for that party involved. So if something hits the fan or the real estate transaction doesn't go exactly how it's supposed to, that legal representation is already engaged at no additional cost to the client.
Yeah, it's definitely a huge benefit. Now in the contract, how do they know, does the buyer or the seller choose the attorney and who's representing them?
Good question. So it depends. In these contracts that we use in Florida, there's 2 that are primarily used in this county, Sarasota, Manatee. We have the as-is or the standard contract. So there's a section 9 of the contract where you either determine if the buyer is picking and paying or the seller picking and paying. Okay. Whoever picks and pays has that representation. So there's obviously advantages to either party paying when picking. If the buyer is buying their brand new first home, they probably want attorney representation to just ensure that the title is clean and clear, the survey is free of encumbrances. But on the other hand, if you're working with a foreign seller that wants to have a lawyer handling it for FIRPTA matters, might want to have your seller pick and pay. So each case is on a case-by-case basis, but that's how you determine it, whoever picks and pays.
All right, perfect.
Yeah, and you mentioned title searches. Can you tell us a little bit about why that's so important?
Absolutely. So anywhere in the state of Florida, whether it is a law firm or a title company, will pull a title search. What that is that's a roadmap to the property. So that's going to show us if there's any liens, any defects on the property, if there's any unrecorded mortgages. We'll have to actually do our own search on that, but anything in the public records that is tied to that property shows on there, and that's our roadmap that we have to delete those requirements towards closing.
Besides the title search, that is really important as you just explained, what other things does the law firm or title company take care of during the process of buying or selling a home?
So what we try to do is ensure that contract to closing is the smoothest, most clean process as possible. So we start from day 1 reviewing that contract and providing wire instructions or the way your deposit is going to be provided to the title company or the law firm. And then we are pulling the title search. We're also pulling a municipal lien search. That is going to show if there's any unpaid utilities or code enforcement violations, any open or expired permits, all of these additional things that we need to review to ensure that they're closed. And again, that's going to determine how the closing proceeds, who we're representing. So if we're representing a buyer, we obviously want all the permits to be closed. We obviously want all the code enforcement liens to be satisfied. If we're representing a seller, we don't necessarily want to take care of all of that. So it just depends on who we're representing at that point. That is going to determine on how the contract is. If there are any liens that we need to satisfy, we prepare any associated closing documents that we need to, any affidavits, any curative forms. and then we record those at closing to ensure that our buyer and our sellers are getting clean, marketable title.
Interesting. Yeah. And so you kind of went into that a little bit, but if you do come up across something in the title search, what's like the standard practice? Are you guys handling that to fix whatever that issue might be?
Depends on what the issue is. So anything standard, yes. So on a standard commitment, we might get an HOA estoppel or a condo estoppel back. That's a requirement. We need to order that estoppel letter to ensure that there's no special assessments that are upcoming that we need to collect for, any unpaid dues. That's definitely something we'd handle. If there's a mortgage satisfaction, we obtain the payoff, we pay that off at closing. So when there are uncommon title issues on the title commitment, that's something that we might not necessarily be able to handle right off the bat. So if there's probate, we do have a trust and estates department that we can assist in that, but we personally aren't going to be doing that in our closing process. If there's a survey issue, we do remedy those survey defects, depending on whether that's a variance or a modification to the restrictions. So that's something that we handle as well. I know title companies do not handle any sort of survey remedies as well. But other than that, as long as it's under the basic umbrella of the closing services for title commitment, we do handle that, and any title agent is going to do that as well.
Okay, well, like how you brought up with the survey, so let's say that a buyer orders the survey and the neighbor's fence is on the property, the subject property. Is it your job to talk to the neighbor to get the fence moved, or whose responsibility is that?
So it depends a little bit, like all legal questions. You probably hear me say that a time or two, but so it depends. In regards to a fence, that's not something that's going to affect title. It doesn't affect marketability because a fence in and of itself is movable.
Okay.
The biggest things we're looking for when we're reviewing a survey are massive encroachments that do affect title, and they affect the owner's policy. So if a house is ever encroaching in an easement, if a pool is encroaching in a setback, those are big issues that we
Okay.
need to remedy in order to get to closing. I have had instances where a fence has been on a neighboring property. All I'll do is let the buyer know, hey, this fence is not technically on your property. If you want to go next door, knock on your seller or your neighbor's door, see how that's gonna go. If you think it's gonna be a little contentious, please feel free to provide me with that neighbor's information. I'll send just a friendly email or, maybe a little call and just say, Mr. Neighbor, this fence is here. I just want to let you know we may be moving it in the future.
Okay.
So I've done that a time or two. Luckily, I've never had any fence disputes because
Well,
those are
that's
never
good.
the good ones to have. So.
That's good. You touched on owner's policy, and I want to go into that a little bit. But before we go deeper in that, I did want to take it back. You mentioned contracts, and with a lot of our buyers are coming out of state, they're used to, if they have had the experience of buying a home before, they're used to a different contract. And you mentioned we have two here in the state of Florida, or at least in the county of Sarasota and Manatee that we mostly use. I know a lot goes into those contracts, they're pretty extensive, but can you go over just briefly what the differences are in between the two?
Absolutely. So we have an as-is contract and we have a standard FAR/BAR residential contract. So the biggest difference between those are the buyer's right to cancel. So in an as-is contract, the inspection period, we kind of call it a free look. So the buyer can cancel if they don't like the color that the sky reflects on the house that day. They don't have to provide any sort of termination reason. Yes, with the standard contract, the buyer doesn't have a right to terminate for the free look period. So they have the inspection period, but they also have the repair limits, and that's really gonna determine whether or not the contract moves forward. So in the as-is, the seller doesn't have to repair anything. The seller has no obligations. In the standard contract, there is a predetermined amount in the standard contract that's going to determine what that will be, whether it's 500, whether it's 2,000, and if the repair limits in the estimates from the inspection period come back in excess of that, that's when there's some cancellation options, but it's not exclusive to the buyer. It can be to the seller or the buyer. So a more buyer-friendly contract in summary would be the as-is. A more seller-friendly contract is definitely the standard.
And it's all situational too. I mean, you could it could be more buyer friendly with a standard because you have that option to have those say $5,000 worth of repairs done. But if it exceeds that amount, then the seller could say, no, I only agreed to repair 5,000. Is that correct?
Correct. So if that happens, and this happens all the time, so we'll use the example of 5,000. If the repair limit was 5,000 and it came back at 6,000, a couple options. There's 3 in the contract. The seller can either say, I will pay that access, so they'll pay the $6,000, or the buyer can say, I'll accept the $5,000 as is, and then I'll pay the additional 1,000.
Right.
The third option is when neither party agrees to accept that extra $1,000. Either party in the contract can actually terminate and be released from all further obligations. So that's why there is some sort of termination language in the standard contract. Highly technical, you have to follow a lot of calendar days. There's 10 days from receipt and then 5 days from a party's last estimate, all of that. But yes, to your point, if a buyer really wanted a property and they were comfortable of spending a little bit more with the repair limit, it could be used, but
Right.
typically I always say as is more buyer friendly because they get that free look. If they want to change their mind, they can.
Talking about the standard contract and the repair limit, something that I would like to add is that the contract is really specific as far as what things are covered under those repairs. Like, it's not everything that they can just come up after the inspection and say, hey, I want you to repair this or that. It's really specific in the contract.
Yes, yep. Section 12B2 in the contract actually dictates what's in working condition and what's in cosmetic condition. So to Stephanie's point, if there's a cracked grout tile or there's some caulking that's messed up, that's cosmetic. That's not gonna afford any sort of repair limit estimate there. It has to be something that's not in working condition. The contract does a really great job defining that by stating not working in the manner intended to operate. So what does that mean? I mean, if the AC is not blowing cool, the AC is not working.
Right.
I've actually had an issue at a walkthrough before, because we do have that maintenance requirement in both contracts, where the pool pump wasn't working. It was working, the light just wasn't on. So in that, I argued that that's a cosmetic condition. Just because the light's not working, the pool is still pumping.
Right.
So luckily we had a standard contract there, so.
So why is it important for a buyer to obtain title insurance?
Great question. So Florida is one of the, or it's not the one of, it is the largest title claim state in the United States. Probably because so many people unfortunately come here and pass. So we have a lot of title claims on probate.
Okay.
Title commitments and our title searches, we do the best that we can. We don't personally conduct our title searches, our underwriters do. That's throughout the state of Florida.
Yeah.
They're not perfect, so it's not robots and machines that are conducting these title searches, it's humans. And unfortunately there are human errors. And a lot of times too, if something wasn't properly probated, or if mineral rights weren't released on a deed properly, somebody else could technically be that owner of that property. So an owner's title insurance is, for lack of better words, a get out of jail free card for that owner. On the day of closing, we are issuing that title free of encumbrances. They're getting clean, marketable title.
Yes.
From the day that they own that property forward, it's stating that we insure that title as is. So if something comes up post-closing, they are protected up to that purchase price amount that they paid at closing.
Okay.
Yeah.
So you guys are the insurance.
So our
Okay.
underwriter is. So
Okay.
we are the ones that issue the policy, but we use Old Republic National Title Insurance, who is one of the largest underwriters in the United States. So they are actually who is the underwriter. So it'd be them paying for that, but we are their issuer.
Good to know.
Okay, so I'd like to go back to some of those beginning steps of getting something under contract. Say we submit our offer and we got this, we got an accepted deal. Typically there's about 3 days to get an escrow deposit due to the attorney's office. But can you tell us some of those other steps that a buyer should be aware of?
So it's gonna be contract specific. It depends, again, let's count how many times I say that today. In regards to the deposit, yes, you're correct. If it's left blank, it defaults to 3 days. It's very important as agents for you to be communicating that deadline with your buyers right off the bat. There's been numerous amount of times where people sign contracts and then jump on a plane to Indonesia and can't get to their bank to make a deposit, or they don't want to wire, they want to mail a check and they didn't FedEx. So they just need to be aware of the contract deadlines when they're signing them. So if they do have an escrow deposit, they're aware of that, they're aware of when it's due. If you're working with international buyers, we have international wire instructions, so we can get those in 1 day as opposed to the typical 5 to 7 business days. that they normally take. If it's financed, they need to be aware of their financing deadline, that they need to make their application within a certain amount of days under the contract. Same with their loan approval. Those are all important deadlines that we at Berlin Patent, we deadline those and
Right.
calendar them immediately. So we are actually telling the buyer, hey, Mr. Buyer, you have this due in a certain amount of days. Or we'll go the extra step and say, hey, we've seen your inspection period is gonna end in 2 to 3 days. Are you working through repairs? Are you negotiating? Or are we good
So
to
they
kind of check this box and move forward?
Right, because at that point they would be wanting to send you addendums or what's just showing you what's being done. But what about, say we send you an offer, send you an executed deal, how quickly should somebody be able to close with you compared to a cash versus a finance deal?
What a wonderful question. I get this once a week. How fast can you close this deal? Again, it depends. So it depends if there's an association or not. So if there is a single family home that is not in a planned unit development, probably 6-7 days. Don't hate me, paralegals, if you're watching. It just really depends. I mean, so if the seller is local, if the buyer is local, everybody can come together and sign probably a week. The quickest one I've ever done is 4 days.
Oh, wow.
So, and that was a condo. So, but if you have an association, statutorily, they have their specified amount of time that they give you back the estoppel. So if the seller doesn't want to pay for the rush, you're waiting those 15 days. If the seller is on the same page and wants to get the deal closed, a week. I think it's always safe to say with cash, 2 weeks. Financed, it really depends on how hungry and motivated that buyer is getting the lender all the documents that they need.
Right.
I think 30 days is probably standard.
Yeah.
It just depends. I mean, I get some lenders that they're clear to close 2 weeks ahead, and then I find out the buyer is an accountant or the buyer is super
really
detailed. It really depends on the buyer and how quick they're being with providing those documents to the lender.
And the type of loan also
Correct.
influences that.
Yeah.
Correct.
The
And how
lender
many
is also-
assets? I mean, if they own 3 businesses, probably going to take
you're
some additional steps. If
Yeah,
you're
self-employed versus
or if
32,
they're-
those things
Correct.
obviously
Yeah.
have effect on the timeline.
So to wrap up, I usually like to ask a question about any story or crazy, funny horror story that you've come across in your many years doing this. Do you have anything that you can think of?
So probably the craziest story that I've had dealt with a seller defaulting. So unfortunately I did represent the seller as well, but she decided she didn't want to sell the home anymore about the day or on the day of closing. And unfortunately the buyers were moving here from Arizona. It was 6 days before Christmas. They had 3 kids and 2 dogs. And as much as we told the seller we really would like her to proceed with closing, the buyers have a very good claim to suing you for specific performance to forcing you to close. Then she ghosted us for about 3 weeks.
Oh, wow.
She sent me a Christmas card in her travels from North Carolina. She ended up, I think her damages were $67,000. Still had to sell the house because she was paying for their Airbnb for almost 3 months. She had to pay for all of their attorney's fees because in Florida we have non-prevailing parties fees sections in our contract. So that's probably the most crazy on a litigation side. And then, I mean, real estate's just crazy in general. I mean, I could probably write a novel. The things that I've been called, some great, some not great, but overall, we all love real estate because it keeps us on our toes.
Yes, there's nothing boring about this.
Exactly.
We loved having you, and we definitely know that this is, with all of our guests, like there's no way that we can cover everything that you do in a 10-minute video, but we do like to keep these short and informative, so we'd love to have you back next time to cover more information
Absolutely, I
about
love that.
Yeah, here's some more exciting stories and just dive a little bit deeper into some more of those hard-hitting questions. And we loved having you, and we really appreciate you coming. And if you guys are enjoying this type of content, please let us know. We'll try to keep videos coming out, and stay tuned for our next guest. Thank you very much, Mallory. As always, I'm Jesse Bauer.
Stephanie Juan here.
Ryan, you're up.
Thank you. Have a good day.
Bye.